What happens when you get injured on the job? In California, workers' compensation generally covers those injuries. Now, workers' comp is what's called a no-fault system, which means it doesn't really matter who's to blame. If the injury happens arising out of employment and it happens in the course of employment, you're generally eligible for workers' compensation benefits. Now, these benefits can include medical care, disability, vocational retraining, and even death benefits to the family if someone dies on the job. But the downside of the safety net of a no-fault system is that you may be limited in the benefits you can get as compared to a civil suit in court, or the system may not be able to respond quickly to immediate treatment needs. The problem is that workers' compensation is also an exclusive remedy, which means you can't generally go to court and sue your employer and recover what you might be able to recover in a civil lawsuit, pain and suffering, and additional categories of damages like future wage loss and the kinds of costs for care you might need for the rest of your life. For minor injuries, this can work out, but for more severe injuries, you can really be limited in what you can recover because you simply can't go and sue your employer in court. Now, in California, employers generally have to have workers' compensation insurance. And so this, coupled with the no-fault exclusive remedy system, while it provides a great safety net, it can also disincentivize employers from taking proper care to prevent injuries on the job. Insurance is going to cover it, and the employer probably can't be held legally liable in court. There isn't really that enhanced incentive to make sure that the worksite is safe for all the employees. So to counteract this, the legislature enacted a law that allows for a different type of workers' compensation claim called a serious and willful claim. A serious and willful claim is designed to hold employers accountable when they consciously disregard the safety of employees, and that leads to injury. An example is, requiring a worker to perform a job without the necessary safety gear, or providing a worker with a broken tool or equipment that they know is broken and could lead to injury. Now, those aren't just oversights. Those are examples of egregious conduct. And in those types of situations where there's this conscious disregard for the health and safety of the worker, well, in those cases, a serious and willful claim can be filed to hold the employer accountable. Under a serious and willful claim, a worker can generally recover more than they could otherwise recover normally through workers' comp. But there's a clock ticking. You only have 12 months from the date of injury to file a serious and willful claim. So if you or somebody you know is ever in that situation, it's really important that you talk to a lawyer right away and talk to a lawyer who knows their stuff, who knows how to answer this question.